In December, the meeting, I was kind of moved with the meeting, and I'd like to read my thoughts on that meeting and see if all of us can agree to maybe change our personalities, be better citizens, maybe more loving and caring. I want to take a moment to address something that's been weighing on my mind. As a public figure, it is inevitable that you will receive criticism, and will not always agree with the decisions you make or the rules you enforce. This is this is a reality we all face, but even more pronounced is when you're in the public eye. However, just because you voice your opinion doesn't always mean you should. We must ask ourselves, what does it say about our character when we use our platform to belittle others? Is it not our responsibility to demonstrate decor and professionalism, especially when you're making a point? I believe it is. No one is perfect up here. No one's perfect setting out there, myself included. But I was deeply disheartened by the remarks made from the podium last month, specifically the derogatory comments directed at Frank. Frank's role requires a level of expertise, skill, and decision-making, but it doesn't diminish his importance. Frank has done an admirable job, and I do not believe he deserves the kind of harsh criticism or anyone on county staff. I urge all of us to strive for a higher standard in our interactions. The more we divide ourselves with hurtful words and actions, the less we will achieve together. Let's choose to build each other up rather than tear each other down. And I'm not doing this because I'm in Frank's hip pocket. I'm trying to do it for us to understand we surely will get a lot more done if we work together, or if, in other words, to beat me up constantly, to challenge me or rudely, you're not going to get anything from anybody. That was my second comment. Now I have one more, okay? Are you ready?
Sir.
This addresses the board up here. Commissioner Delaney's requested a board scheduled workshop on January 30th to talk about fire rescue. Since the scheduled workshop, county's negotiation with firefighters union remains unresolved. In fact, there's a mitigation tomorrow and potential special magistrate hearing February or January. The county attorneys advised us with letters saying, hey, you can't get involved in this as elected officials. All right. Did everybody read the letter? So therefore, I'm making a motion that if she would like Commissioner Delaney would like one, she's welcome to have it in her district. I will not be attending because I don't want to be charged by anybody for anything that I can read the letter and say that we're not supposed to be involved. Thank you, Chair.
I have a question about that.
Okay, I think that's fair.
Morris, can you explain that a little bit? And is there a law, or is it a policy, or is it a PERT issue? What is the issue?
What's all of the above? It's Florida statutes, it's the contract with the union, and it's your board policy 99. But those all address when we're in negotiations, limitations on communications between the union and union members and the elected officials. All negotiations are supposed to go through the chief executive officer for the county. That's the county manager and his negotiation team with the union. And as we're still in negotiations, and particularly since we're at a point where the union has declared impasse, we've got the mediation scheduled. We have tentative hearing dates for a special magistrate hearing if needed, if this isn't resolved following mediation. So there is concern that the topics that would be discussed at this workshop, it's going to be very hard to have a workshop where, almost necessarily subjects that are mandatory subjects of bargaining are going to be discussed by both elected officials on the dais, but
If I could pause you for a second. you're preempting discussion that hasn't even happened yet, is what you're telling me. And so this was an opportunity to bring the public into this conversation about the fire assessment. And Commissioner Goodson, you talk about professionalism and courtesy and all of that. Yet, I was not told that this was going to be brought forward here today, and I'm frustrated that this conversation did not take place when I brought forward the idea.
So at that time, everyone was hopeful, I think, that the negotiations would resolve, we would get somewhere, and that we wouldn't be at a point where we're still at impasse and where we are. But it looks like, looking at the schedule now and where we're at.
But again, you're preempting the public. This is why we pay you. This is your job, is to stand in line when something happens that's unlawful. You step in and say, hey, this topic is off limits. We can't talk to this because of Florida state statutes, so on and so forth. But to cut off the public from being able to have a voice in this conversation about the assessment is wrong.
We wouldn't be able to cut off the public at a workshop we'd be inviting issues. So it's certainly problematic.
Maybe.
Almost certainly. I mean, the first thing listed on the agenda for the workshop is about hours and working conditions, which is a mandatory subject of bargaining. So it's during negotiations, those are the kind of things that we shouldn't have in a forum like that.
I mean, I'm sure that we can speak about hypotheticals and philosophy without talking directly to negotiations. Is that correct?
There was a list of 3 items for the workshop. The very first one is about subject of mandatory bargaining. It's not a hypothetical. It was your agenda item.
Right. And my point was to talk about the philosophy of how the fire industry is changing and how do we want to be at the forefront of that, since our community is so dynamic, probably the most dynamic place in the country. For what our firefighters have to deal with. And so it was to talk about the broader conversation of what do we want our fire service to look like here in Brevard County. That has nothing to do with negotiations.
So I've advised about the pitfalls and the potential issues, and I can certainly, if the commissioners would like, push a light whenever we get into a sensitive topic. I haven't said you can't have the workshop. It's a commissioner's motion to I'm not sure exactly what the motion was, move the workshop or
cancel the workshop.
Or cancel the workshop.
Because of your letter and the state laws and the county ordinances.
But I think
But
the timing of the workshop and the current state of negotiations currently problematic. Now, if there's a good resolution at mediation that comes back to the board before then, may not be an issue, but it's something you've got on the calendar right now.
I just want to put this forward that I think that this is a tactic, and I'm embarrassed.
Comment.
All right.
Comment. A tactic that I did and you're embarrassed by my motion?
Frankly, I don't know who.
Huh. Well, you can still have your workshop. Go
The
to
whole
it.
point is so that the discussion can be had with the public and the commission as a whole.
You're a
Are we
commissioner.
one person or are we a board?
Well,
And so it
depends
was
on-
brought forward.
It depends on what area you're in.
I would think that everyone in Brevard County is thinking about this fire issue.
But when your attorney tells you could get charged with something, do you go blindly down the road?
No, but that's why we have him.
Okay,
We pay him the big bucks.
Okay.
All right, you're right.
Commissioners, with respect, we have 2 other commissioners here. Let's let them weigh in on this. Commissioner Altman, I believe you were first, sir.
Yes, thank you, Mr. Chairman. Is it possible our counsel, could he read us the Florida statute that we're talking about? I think it would give us some understanding about what we're talking about.
Well, I don't have that open right now. Give me some
Well, let's,
time. I do have available pretty quickly your board policy 99. Give me one moment for that.
I'll tell you what, let's go to another question while he's
Sure.
looking that up.
Right,
Is that
thanks.
good, sir? Okay. Commissioner Atkinson.
Well, mine was going to be for Morris as well. And I had two questions. Very simply, what can't we talk about? What are we not allowed to talk about? And then secondly, what kind of trouble do we get in if we do?
So what you can't talk about are pretty much, anything that relates to anything that's a mandatory subject of bargaining. And that includes things like working conditions, wages and hours, salary, health and safety, management rights. There are a whole laundry list of things that are mandatory subjects of bargaining in a union situation. And it's just hard to conceive of a workshop where you talk comprehensively about fire rescue, and certainly about hours of work without getting into mandatory subjects of bargaining. What could happen, you could be charged with unfair labor practice. It's a violation of both our collective bargaining agreement with union, but also, again, board policy and chapter 447 of Florida statutes to engage in all those during negotiations. Everything is supposed to go through the chief executive officer for Brevard County, who's the county manager, taking direction from the Board of County Commissioners. And county manager's been receiving direction from the board both before and during the negotiation process. So the board gives direction in the form of budget development and things like that. Board also gives specific direction in the context of collective bargaining at your executive sessions on bargaining, one of which you had last month.
Okay. You're still finding a statute there for Commissioner Altman?
Well, I am, but really it's a number of, statutes. It's not one specific provision, but it's throughout chapter 447. But those are sort of summarized and collected in BCC 99, which is states that the purpose of this policy is to ensure good faith negotiations between Brevard County and public employees pursuant to Florida statute section 447.201 et sec, where applicable. Also articles set forth in the county's collective bargaining agreements. Pursuant to the collective bargaining agreement, it talks about the certification of the union as the representative of the county employees. Pursuant to Florida statutes 447.309, the bargaining agent for the organization and the chief executive the organization being the union, and the chief executive officer of the public employer, that's the county manager, shall bargain collectively in the determination of the wages, hours, and terms and conditions of employment of the public employees within the bargaining unit. The chief executive officer or his or her representative and the bargaining agent or its representative shall meet at reasonable times and bargain in good faith. In conducting negotiations with the bargaining agent, chief executive officer, or his or her representative shall consult with and attempt to represent the views of the legislative body of the public employer. But it's not a direct negotiation between legislative body of the public employer and the union. It's between the chief executive officer taking direction from the legislative body and the union. Article 1.05 of the collective bargaining agreement, quote, recognizes that the county manager and designees are the collective bargaining representatives for the county. The union further recognizes its obligation to bargain solely and exclusively with the county manager and or designees, and to refrain from any direct negotiations with the legislative body of the county commission, or any of its members regarding work-related issues. Then it lists all the mandatory subjects of collective bargaining. Some of the things I've listed: wages, hours, fringe benefits, health and safety, length of contract, management rights, seniority, dues collection, things of that nature. Then pursuant to 447.605 Florida statutes, all collective bargaining negotiations between a chief executive officer or his representative bargaining agent shall be in compliance with the provisions of section 286.011 Florida statutes. That's sunshine. So that's why those collective bargaining agreements between our negotiation sessions between the entities are publicly noticed and subject to sunshine. And then your policy says, it goes on to say, member of the Board of County Commissioners or their staff shall not engage in discussions or negotiations with a member of a labor union or a representative agent of a union during a period of formal negotiations with said union regarding any subject which is related to a bargaining agreement.
I have a question.
Oh, hold on. I'm sorry.
Sure.
Commissioner Atkinson was ahead of you there. Go ahead.
I know there's a motion on the table to cancel the workshop. I was just wondering if Commissioner Goodson would consider a friendly amendment to maybe postpone it, or
Let me hear your man.
just to perhaps discuss an alternative day. I don't know how we would pick a day, but a day that would keep us out of trouble.
Well, I think that's a question for Morris. So let's get clarity on that real quick. So Morris, could it be postponed where the cone of silence, we don't violate that, or the collective bargaining process? What
Absolutely.
What could be an option available to us in the fire?
Yeah, absolutely.
Okay.
I mean, the workshop can absolutely happen once negotiations are concluded, and however that occurs, whether that's through mediation and then bringing back a mediated agreement to the board, whether we go all the way through the entirety of the impasse procedures and it ends up in front of this body to make a legislative decision. Once those are concluded, regardless of how they conclude, you can absolutely have the workshop and talk about anything.
Can I ask one question before we make that motion?
I understand. We're going to make sure everybody asks their questions before we vote on anything. Okay. So go ahead, Commissioner.
Morris, can we direct the chief executive officer to make the county commission the designee on January 30th?
No.
Why not?
Why not? Because the whole system is set up so that the
I
CEO.
With all due respect, I'm asking legally why not.
I'm telling you.
Okay.
All right. The whole statutory scheme of Chapter 447 is designed so that the chief executive officer is the bargaining agent of the county. January 30th is the workshop date. Did you mean?
Correct. That way we're not in trouble because we're
What-
we're the chief executive officer.
No, because if this, for example, if this doesn't resolve at mediation, if this goes to a magistrate hearing, at some point, you're going to have to make a decision on the contract as a legislative body, and you're going to have to do that as a neutral. You can't both be the bargaining agent and the ultimate decider as a neutral.
I'm saying
You
for the
can't wear
4
both of
hours
those.
that we are
No, once
running this
you couldn't wear that
workshop.
hat and take it off and not have been, no, that's not the role of the legislative body.
I mean, our role is everything in regards to the county. So I respectfully disagree.
No, you absolutely cannot directly negotiate with the labor union. You can't take on that role. That's an absolute legal clarity.
Okay. We have another commissioner in here, if you don't mind. Commissioner Altman, you're recognized, sir.
Thank you. Thank you, Mr. Chairman. So, and I appreciate your effort to keep us legal, that we follow not only the letter of the law and the spirit of the law. So I do have a question. I was reading some of the statute, and I know we're talking about the budget, but I was a little surprised that in 447.309 2A, again, this is a process question, maybe help clarify. I was surprised it talked about the actual budget. It says, upon execution of the collective bargaining agreement, the chief executive shall, in his or her annual budget, request or by other appropriate means, request the legislative body to appropriate such amounts or shall be sufficient to fund the provisions of the collective bargaining agreement. That sounds like it's telling us that we don't talk about budgeting money until we have a collective bargaining agreement. Am I wrong how I read that, or what is the intent of that statute in your opinion?
I understand why you would say that. I think it's saying that once a collective bargaining agreement is reached that's approved by the legislative body, then it's an obligation of the county manager as he prepares the budget to account for that agreement within the budget. So the budget that he presents to you has to be adequate to honor the collective bargaining agreement. I don't think it's telling you that you can't talk about budget in the absence of a collective bargaining agreement.
And follow up. That's helpful. That's helpful. So would it be possible for us to have a workshop to only talk about the budget, just talk about the fee, the fiscal impact of the fee, levels of service?
The board can, and there are budget workshops that are scheduled. Now, the specific purpose of this workshop, the first item on the agenda is
Right.
about, hours and working conditions, and it's just going to be very difficult to draw that line. So again, I'm not saying you can't have the workshop. I'm wondering though, if you want me here blowing a whistle every time
Right.
we run astray, and probably more difficult is that if you have public comment at the workshop, this applies not only to union representatives, but union members. Very difficult, we're in a bad position if we're having to stop the public as they're speaking. So it would be very difficult, not impossible. Again, not saying you can't have the workshop, but is it advisable to have it after negotiations are resolved? Would it be more productive?
Yes, thanks.
But
Thank you,
that's a decision
Okay.
for the board.
But
Thank you, Mr.
maybe
Chairman.
Commissioner Delaney, you could help me with some clarification here, just actually help us. The goal of the workshop is for us as a board to discuss in the open the issues, because I think maybe there's two things happening in here, and or to allow the union to come in to air their grievances, and that's okay, either one.
Yeah.
But it may be that there has to be one or the other. That may be the path. So can you clarify what it is that you hope to do in the workshop, since it originally was your item?
It's the first one that you talked about. I'm looking also for an avenue where we can solely talk about this issue as a group with the public. Because, and when I say the public, I've said it multiple times, that it's frankly not just about our firefighters. And I say that with all due respect, but it's about our public as well. They need to have the opportunity to speak to us about this and tell us what is important to them and what they're willing to do to participate in helping with all of this. And maybe they have some great ideas. Maybe, we can talk about some things like purchasing during this time, because we need to do a deep dive into our budget about and figure out how to get some funding from within our budget to fund our fire department, not just the fire assessment, but it needs to be, like I've said multiple times, it needs to be the fire assessment. It needs to be the us talking about impact fees. It needs to be finding money within our budget. I know of a project today, $36,000 on a shower, literally a stall shower, that we spent, and it's leaking. So we really need to look into all of these things and have a designated time and space where we can give our fire department the attention that it desperately needs. Or, we're going to find ourselves in a real emergency situation.
I appreciate that. But it's so, listening to the county attorney, it seems that the only sure bet for a workshop that doesn't potentially get us in a collective bargaining conflict legal problem is that the board could have an open discussion and with staff, and the public could come, but not with public comment. Now, I understand that. I understand that nobody likes that. But Morris, am I interpreting that way correctly?
I haven't thought about that specifically. I'd be concerned about that. First of all, you couldn't take action, because if there's an item you're going to take action on, you have to allow for public comment.
But I think by
But-
virtue of having a workshop, we're not taking action. We could give board direction at a workshop, but we don't vote to pass items without noticing it. Is that? I'm just trying to split it with you here and
My-
try
my
to find us
concern
a
with-
good way and
I mean,
not have a
everything as
legal
far
problem.
as far as budget development and setting the assessment rates and things like that, you can absolutely talk about all that when the time is right. But the budget development process, I mean, we're going to have budget development workshops in March, and that will be part of the budget development. Hopefully this is all resolved by then. Hopefully by January 30th, we have a contract. That would be great. And then again, no concern with any of the subjects. But I think at this point, it would be very difficult.
Sorry, Commissioner.
I understand what you're saying, Mr. Chair. I have some, I'd want to consult before I'd say that the one-way sort of discussion, board only, is okay. That in itself might be problematic too.
If I could just say one thing.
Well, Commissioner Altman wants to say something also. Let's let him just speak real quick, okay? Commissioner Altman.
I think I found the part of statute that really applies here. And this 447.605, all discussions between the chief executive officer of the public employer or his or her representative and the legislative body or the public employer relative to collective bargaining shall be closed and exempt from the provisions of 286.011. That's pretty doggone clear. It's a shall, it's a must, and it's all discussion. So I agree with our general counsel. I know it's not easy, and it's not maybe. I like the idea of the public workshop, but it does put us at odds with state law and the collective bargaining process, which we've already engaged on. I thought maybe perhaps we could waive that provision, but it's pretty clear in my mind, and we definitely want to follow the law. And hopefully we'll get there in the same place. I think you and I probably see a lot in line on this issue, and I hope we can get there. But we definitely want to follow the process the way it's set forth in law.
What if I take away that first bullet and we speak to the assessment, and like I said, the budget? Is that appropriate?
If I could, I don't mean to answer a question with a question, but how do we deal with the public comment portion of it? Because it is a two-way thing. Go ahead.
My concern with taking any action without the public's input is this greatly affects them. And so for us to give any kind of board direction without their input, I feel like that's just wrong.
I don't disagree with you, but we are going to have a vote on the final product before this board, aren't we? You're going to present that to us?
Yeah, there's a couple of ways that could happen. First way is if there's an agreement either at the mediation or a special magistrate makes his recommendations, and both the board and the union accept that, then we would bring that contract back to the board for approval. The second way is if there's a dispute, if you don't have a settlement before the special magistrate makes a recommendation and either party does not accept any recommendations, that comes back to the board. And that's what Morris was talking about. You serve as the impartial there between the union and the management. Whatever the difference is, it comes back to the board at a public hearing. The board at that public hearing makes the decision as to how it's going to rule. So the public is that part of that process, because that is a public hearing here in front of the board, and that's the statutory process that's provided for by 447. Morris can probably speak to that issue more.
Okay, so having heard all of these things, let's just take it apart, because I think we're still having a public meeting, okay, to discuss the product. And so certainly, I mean, at that meeting, we could have many cards and all of that. At a workshop, we would have the same thing. So maybe that's all going to happen just at a commission meeting rather than a workshop. Is that? I know that's, I know it's not what you want, but we might get to the same place. You're going to end up with all of the same input, the same discussion. We can have it up here. It's probably the best proper legal way to do that is Morris, does that sound right to you?
Yes, and I think the board has received input from the public throughout at your various meetings. There's been, probably hundreds of public comments made on the issue of negotiations in the contract since going back to the workshop last year and multiple meetings over time. So I think the board has heard public comment, but just as we navigate this negotiation and impasse period, we all need to understand what the parameters are, where the rails are, and that the board is not the negotiating entity and just can't be by law.
Okay, Commissioner Delaney, what do you think about that in lieu of the workshop?
Well, I would definitely like to still have the workshop if the board would like to do that. I still think that we need to designate time to this topic. And while I heavily object to working in front of the public as far as assuming that they're going to bring up something that they may or may not bring up, something is better than nothing. And I believe that I'm hopeful that you all will agree to still having a workshop.
I don't disagree with your comments there on not having public input. I think I've demonstrated that on this board since I've been here. Commissioner Altman, is that a new light, sir?
No.
Okay. Commissioner Atkinson. Okay, so would you see that at a commission? Because I'm going to try to split it with you. I try to as much as possible. If we instead, what if we postponed the workshop and we altered it? Okay. And we still agree, we could agree now to have a workshop in the spring after the impasse period and the cone of silence and all the legal ramifications of that. And that workshop at that time be dedicated to the fire assessment fee in the millage. So rather than part of the larger budget, we'll have a workshop just on those two issues. So you could call it method of funding. Would that be a compromise with you here on this legal process that we seem to be stuck in?
I feel like our people, we won't have a fire department at that point. If we don't show our people out there that we are actively working towards this and engaging the public and engaging our fire department, I don't believe that we will be in a good place in the spring. And canceling this will just kill more of the morale. And I'm frustrated that my county manager and county attorney did not talk about this to us prior to me putting this agenda item out, because I was very clear on what my intentions were. We had briefings about it. We had conversations about it. And now in the, 15, 16 days prior to this, and when we have mediation tomorrow, now we bring this up. And
I think when we booked, with all due respect, I think when we agreed to the workshop, we didn't have a calendar before us on when mediation would happen. Those other legal requirements in the collective bargaining, that we didn't have that information at that time. So
with all due respect, that doesn't negate my point that this is supposedly a legal problem because we're in the impasse process. And if that were the case, I should have been told that prior to this point.
Yeah, I mean, we've had those discussions about appropriate topics of discussion for the workshop and what we can talk about. We talked about it most recently at your briefing. So that has been raised. But again, when this was scheduled, we weren't where we are now. and you have to react to the developing reality. Again, I'm not saying there's a law that says you can't have the workshop. I'm just saying you're going to be very, very restricted on what's appropriate to discuss. And based on some of your statements, you know, the purpose of the workshop can't be about the current ongoing negotiations. That can't be a topic of the workshop at all.
And it wasn't.
Okay, Commissioner Goodson, sir.
Question, was it, when you asked for a workshop, then I think Commissioner Altman asked you to, did you ask her to write down what she wanted to do at the workshop? Do I recall that?
Yeah, you may be right. Your memory's probably better than mine.
I doubt it.
Commissioner.
Okay, but
Yeah.
then you,
I may have. I don't remember.
okay,
No.
then you provided us a list of what you want to do at this workshop, 1 through 10 or 1 through 5, right? Right?
I made it maybe more into a pretty package.
Okay, pretty package or
Right.
bad package. You gave us what the parameter you wanted to do, right?
Sure.
Okay. So that gave Morris the first time to look at it and,
I disagree with that.
okay, well, I mean, I'm glad you do.
Yeah.
What can you agree on then? Nothing?
A lot.
Okay.
A lot of 5-0 votes tonight.
Is there any way is there any way that we can consider things at the January 28th meeting before making a final decision tonight?
Absolutely.
Is that a possibility?
Absolutely.
Okay. Given that, what does the rest of the board think about that?
Well, I have a motion.
Mr. Chairman,
Okay. Okay. Commissioner Altman, go ahead, sir.
I'll second the motion.
Is there any further discussion on the motion?
I appreciate Chairman Feltner that you suggested waiting on this until the 28th, and hopefully, hopefully good things will happen tomorrow. So that's where my support's going to be for.
All right. We have a motion by Commissioner Goodson. We have a second by Commissioner Altman. Clerk will call the roll.
Can you repeat what that motion is?
Commissioner Goodson.
Motion is to cancel the workshop.
Thank you.
Mm-hmm.
Commissioner Delaney,
No.
Vice Chair Goodson,
Yes.
Commissioner Atkinson,
Yes.
Commissioner Altman,
Yes.
Chairman Feltner.
Yes. Okay. I think that was technically Commissioner Goodson's board report.
Yep, that was it.
All right. Let's go to the other end here. Frank, on board report.
Hey, this is Jerry with On Point Wildlife Removal. If you think you might have critters in your attic like squirrels, bats, rats, or raccoons, give us a call today. We'll come out, we'll take a look, we'll give you a free quote to get them out, to seal up your home, and clean up whatever mess they left behind. We're locally owned and operated, and we're fully licensed and insured.